welcome to Crime in Court. My name is Heather, and this is another recap of the Delphi trial. And we are talking about, obviously, Indiana versus Richard Allen in the Delphi case. And this is day three. We're going to go over first, we got some motions, and then we've got some testimony recap and all the big things, all the big highlights from day three we're going to go over. So please hit the like button and let us begin. All right, so first up is a motion from the defendant. So right after the weekend, day two was Saturday. We got a motion from the defendant going into Monday morning, and not not just from the defendant, but we also have a third party that is a motion for leave to intervene for public access to records. And this was actually done by Andrea Burkhart, who is a content creator on YouTube. She has been at the Delphi case on foot, and then, boots on the ground. And then she is giving recaps on her YouTube show on her YouTube channel every day. So, she's like, hey, why is it that the media are the only ones that can get access to these court records? Judge Gall is hiding them from the public, it appears or seems. She doesn't want info to get out or whatever. I don't know. Yeah. I mean, I understand keeping out graphic images and not allowing those to be public, but other things in this case I think need to be made public in order to shine light on this, because this is the darkest case. Like, there's so much that we don't know, and I think that is being covered up by law enforcement in here. But anyways, let's begin with the defendant's motion in limine. This is regarding the videos on the victim's phone. So Libby, as we know, had a cell phone. Abby did not. And Libby captured Bridge Guy, the video of Bridge Guy that we're all familiar with, that they loop for us to watch, and also the words "Girls Down the Hill," which the media released as well, way back when, to try to help identify who it could have been. Well, remember the sketches. The state just filed their motion in limine regarding not allowing the sketches to come in because they were only there to as a tool or an investigative aid. They weren't there to technically identify. They weren't there to use to identify Richard Allen or something along those lines. And she allowed that. She said, "Okay." Judge Gull was like, "Yeah, sure, that sounds about right. Let's hide the fact that we had two different sketches of two different people that look nothing like the suspect that's on trial here. Let's just hide that." But okay. So anyways, she agreed. Let's not show those pictures in court. Well, kind of as a FU to the state, the defense followed their lead and said, we don't want to solicit testimony, or elicit is actually probably the right word. We don't want to elicit testimony from anyone regarding the voices that you hear on the video, because I guess there is more content on Libby's phone. Obviously, she was a teenage girl. She probably took tons of videos and pictures and all that good stuff. So there is some video or something we're finding out now that has the victims' voices on the record, apparently on tape or on video. So let's read what this says here. Sorry, my coffee's getting cold. All right, so comes now the defendant, Richard Allen, by counsel, and moves the court to prohibit the state from eliciting testimony as to the words and sounds allegedly contained in the video recovered from Liberty German's cell phone. In support of this motion, the defendant states as follows. Number one, the defense believes that the state will seek to introduce video and audio enhancements of the video recovered from LG's cell phone, that's Liberty's phone. Said video was taken on February 13th, 2017. So we know it was taken on the 13th. They were found the 14th. The timeline, somewhere in between, we don't know exactly what happens. So, number two, the video and audio enhancements contain words and sounds. So they enhanced the video and audio, FYI. So it has been retouched by law enforcement. Number three, one of the audio enhancement files received by the defense contains a phrase seemingly uttered by one of the victims, which phrase is repeated on a loop. Again, they altered the video or audio. If they're playing it on a loop, it shouldn't even come in, but that's my opinion. But they probably figured they wouldn't get a positive, positive response from Gull if they tried to eliminate the video altogether. Number three, one of the audio enhancement files received, sorry, I read that one, the voice of the victim on a loop. Number four, one of the audio enhancement files received by the defense contains an audio clip of a man speaking, which is also repeated on a loop. That's the girls down the hill. The words allegedly spoke by the victim on the enhanced video, so by the victims, the words by the victims on the enhanced video are difficult to understand. The defense requests the court prohibit the state from eliciting testimony concerning what words are spoken by the girls on the enhanced audio. They don't want the state to be asking any of the witnesses, what are they saying here, or what did that sound like to you? They want the jury to decide for themselves what it sounds like, if they can even determine. Number seven, the defense requests the court prohibit the state from eliciting testimony concerning what sounds are contained in the enhanced video and the man's voice with the man's voice. The video and audio enhancements appear to be investigatory tools. Isn't that what the state argued? They're just investigatory tools. So they don't need to come into trial. I love it. Kind of a little dig back at Nick. All right, number nine, interpreting the words and sounds on the enhanced video requires a completely subjective analysis. 10, testimony identifying the words and sounds on the video is speculative and I would venture to say improper. 11, the enhanced videos are not related to the identification of Richard Allen as a suspect. Same argument that the court or that the state used to eliminate the sketches. They were investigative tools and they were not related to the identification of Richard Allen. Therefore, the sketches are not relevant under, they probably meant to say here, therefore, the videos are not relevant under that, under Indiana Rules of Evidence 401. All right, number 12, due to the poor quality of the enhanced video and audio recordings, the probative value is low. Allowing a witness to speculate as to the words and sounds of the recordings would put ideas in the jurors' heads. Yeah, we don't want to put ideas in the jurors' heads. That would be confusing and misleading. Same exact argument that Nick used to eliminate the sketches. Hilarious. And if she says no, if she denies this, like you can tell there's just pure bias there. Number 14, it is up to the jury to determine what words or sounds exist in the recordings. Number 15, additionally, allowing the enhanced recordings to play on a loop is repetitive, cumulative, and unduly suggestive. I like that. Wherefore, the defendant, Richard Allen, by counsel, respectfully requests the court prohibit the state from eliciting testimony identifying the words or sounds on the enhanced recordings and for all other just and proper relief in the premises. So that is the defense's arguments, which basically they just threw right back in the state's face their own arguments as to why they shouldn't. And they're not even saying don't put the video in to evidence. They're allowing the video in. They just don't want the audio, I guess, looped because it's repetitive, but they also don't want anybody to make any suggestions as to what is being said by the victims in the recording. So, if she says no to that, I mean, it's pretty clear because they use the exact same words, putting ideas in the heads, being misleading, confusing, and they're just investigatory tools. That's all. Same arguments that the state used, and I love it. Little snark from Jennifer Auger, who is the female attorney that is on the defense team, who we don't hear from very often, but she does a lot of the motions, I believe. She writes some of the motions and does a lot of work on the inside that we don't see. All right, so up next is this lovely filing from Andrea Burkhart, motion for leave to intervene in, and for public access to court records. This woman, Judge Gull, if you can call her a woman, I can't stand her. I think she's evil. I think she's Satan incarnate. um, but yeah, so this woman is doing everything she can. Judge Gull, the dishonorable Judge Gull, is trying to do everything she can to keep the public away from this trial, to keep everything secretive, to limit the public's access to this trial. She has eliminated any possibility of video, audio, transcripts, even. She is pretty freaking evil, if you ask me. And I mean, what are her reasonings? She never gives a reason. She just denies everything without hearing. And that just, it shows me that there's something that she's hiding. And I want to know what. All right, so Andrea Burkhart, pro se, as a member of the public at large, respectfully submits this motion for leave to intervene and for public access to court records in the above captioned cause. In support, Ms. Burkhart states the following. I am an attorney licensed in Washington and Oregon and a legal commentator on a variety of internet-based platforms. Speaking of that, Judge Gull apparently doesn't think that any content creators or individuals who have a platform on social media are media. She just she won't allow them in her courtroom as media. They have to be from like an ABC, NBC, like one of those kinds of big stations that don't always report very well. But luckily, we have citizens on the ground that are going and watching and taking really good notes so that we can learn what's going on in this trial. So, anyways, let's move on or keep going. So, at the time of this writing, I have 89,000 subscribers on YouTube, over 67,000 subscribers on X, formerly Twitter, and over 1,400 subscribers on Substack, where I provide legal analysis and reporting on high profile cases, including the subject cause, the prosecution of Richard Allen for the homicides of Abigail Williams and Liberty German. So she's being upfront. She's like, I have a platform and I report on these guys. I report on this case. Tens of thousands of viewers are watching my coverage. This is the first time I'm reading this out loud, or I haven't read this yet. Like I've been so busy trying to cover multiple cases right now, and I think I'm gonna be here for whatever Andrea has to say because I like how she's starting out already. Tens of thousands of viewers are watching my coverage of this trial and rely on me for detailed information about the trial proceedings, as well as my interpretations and opinions about what is transpiring. I am not an employee or representative of a traditional press outlet such as a newspaper, television station, or wire service, and therefore do not qualify as quote unquote media within the meaning of Indiana Judicial Conduct Rule. So she's totally upfront. This is who I am. This is what I do. I have a vested interest in this trial. Number two, despite overwhelming public interest in this case, this court has repeatedly denied requests to broadcast this trial to the public, entering orders denying broadcasts broadcast requests on October 27th and May 16th. The court also denied a request by news media to record court proceedings by order dated September 11th of this year. And finally, the court denied a request for recording of court proceedings by Wish TV by order dated October 16th. And we were using one of the um, anchors from Wish TV as a source. She's got good coverage on her X page. All right, so number 3, trial in the above captioned matter began on October 14th with jury selection in Allen County. The trial has advanced to the presentation of evidence beginning on Friday, October 18th, meaning the trial started on the 18th. Because the orders denying broadcasting and recording of the proceedings limit the scope and quality of information publicly available about what is occurring during the trial, I have traveled approximately 2,000 miles to be able to attend and report on this trial. Like, F you, bitch, because you made me travel 2,000 miles in order to access this trial because you suck. These costs should be on you because all you have to do is sign a document and voila, you can broadcast this to the world and we can all see the truth. But no, she doesn't want to do that because she's hiding something. All right, let's keep going because I should stop interjecting because I get angry and annoyed. All right, so number 5, as a result of the trial's inaccessibility to public view, numerous members of the public and media have likewise traveled to the small community of Delphi, Indiana, in an effort to witness the trial in person. With the court's allocation of reserved seats to the families and the victims, the defense, and the media, there are 24 seats in the courtroom available to the public. That's not a lot. Far more members of the public wish to attend than the courtroom can accommodate, which has resulted in long queues outside the courthouse beginning as soon as the preceding night. For example, when opening statements were scheduled to be presented on Friday, October 18th, I arrived at approximately 3:30 a.m. and was already approximately number 22 in line for admission. Holy cow. See what she did? Like, she's making it a circus by not allowing the cameras. I have been further informed and believe that members of the local community who have been personally affected by the crime and would like to attend the trial are discouraged from doing so because of the crowds. I am aware that Rule 5 of the Indiana Rules of Criminal Procedure requires the trial court to maintain an electronic recording or stenographic record of all oral evidence and testimony, rulings admitting or rejecting evidence, objections, and any other oral matters occurring during the proceeding. The rule requires either a printed transcript or the electronic recording to be produced and maintained as a court record for 55 years in felony cases such as the present matter. Holy mother load of, I'm just going to throw a bunch of case law at you and tell you how you're violating it. Under Rule 3B of the Indiana Rules of Access to Court Records, such transcription or recording constitutes a case record because it is an item created or maintained by a court in connection with a particular case, and a case record is a court record. So there's no confusion there. Furthermore, under Rule 3F of the Indiana Rules on Access to Court Proceedings, public access includes the ability to both inspect and copy a court record. Accordingly, public access is denied if the court does not permit the public to obtain a copy of the transcript or audio recording of trial proceedings. I am further aware that under Rule 4 of the Indiana Rules on Access to court records are accessible to the public subject to specific exceptions enumerated in Rule 5 that do not apply to the transcription or recordings of the present trial. Under Rule 4D, while the court may manage access to the audio recordings of proceedings to avoid substantial interference with the resources or normal operation of the court, this provision may not operate to deny any person the right. So she may not operate in a way to deny any person the right to access the public record. And that is the transcripts or recording or audio or video recording, any of that. That is public record. Well, more so the transcript of it, more than anything. But yeah, she's denying that to the public. By this motion, I am requesting copies of the transcription or audio recording of each day of the trial proceeding in this matter beginning October 14th and continuing until its conclusion with a verdict or other resolution. Recognizing that providing the copies will require the use of court time and resources, I am happy to receive the copies in digital format through an electronic medium such as email or through a cloud-based information storage provider such as Dropbox or Google Drive. Alternatively, I would be happy to provide thumb drives to the court upon which the digital files can be copied. Based on my experience in obtaining and transmitting court records in various formats in multiple jurisdictions, I believe that this would impose only a minimal burden on court staff as it would require little more than dragging and dropping the digital file already created to the storage medium and notifying me that the file is available to be picked up. Easy, right? I mean, she's not asking for that much, and she's going to help you out in case you need help doing this. She'll even give you a flash drive in case you are still going to be difficult and deny her this record. Number 10, I am aware that Rule 2.17 of the Judicial Conduct Rules affords the court discretion in deciding whether to allow the independent recording or photographing of the courtroom and the broadcasting, televising, or digital streaming of the trial, and I am not requesting to revisit or reconsider court's orders denying the media's requests to allow cameras in the courtroom. However, I believe that permitting the public to witness the trial through the transcription or audio recordings of the proceedings will decrease the distractions in the courtroom and improve the dignity of the proceedings consistent with Rule 2.173A by decreasing demand for access to the courtroom and will further alleviate the burden of the court and the community resulting from competition for the limited public seating that is necessary for direct access to information about the trial. This will further benefit the community by freeing up the limited courtroom seating for those local residents who have been traumatized by this crime and for whom personal attendance at the trial would be healing. That's a great point. This is good, Andrea. This is good. All right, number 11. With the commencement of the evidentiary phase of trial, the court has admitted several exhibits proffered by the state and the defense. On October 1st, 2024, a coalition of news media organizations filed a motion to inspect the public trial exhibits. By order dated October 16th, the court granted permission to the media to view the trial exhibits at the conclusion of each trial day, but they only get 15 minutes to look at the exhibits, which is crazy because, like, one day they put in like 60 photos or something. The order makes no provision for any member of the public to view the exhibits on the same terms as the access granted to the media. Public should still have access to these documents. During the trial, paper exhibits have been published to the jury by simply handing them the exhibit or copies of it to review. These exhibits cannot be seen by the public seated in the gallery of the courtroom. Digital exhibits have been published on a large screen that is oriented to face the jury box. This screen has not been visible to some of the seats in the gallery. Consequently, the only way for the members of the public attending the trial to be assured of their ability to view the exhibits that have been introduced is through public access similar to that afforded to the media attendees. I was present in the courtroom at the conclusion of the trial day on October 18th, so day one opening statements, and observed that the proceeding for viewing the exhibits was to place the exhibits on a table in front of the jury box and invite the media into the well to view them for the allotted 15 minutes that they have. I am informed and believe that a member of the public attempted to enter the well to view the trial exhibits on Sunday, October 19th, or Saturday, October 19th, at the conclusion of the trial day on the same terms as the media and was prohibited from doing so by the court. I believe this is Ali Mata. She tried and she got yelled at by Judge Gull. And Judge Gull knew exactly who she was, I think, by calling her out and saying, no, sit down. I think she knows who the content creators are, and I think she wants them nowhere near her court. God, I hate her so much. All right, where did I leave off? Yeah, she ordered the individual to leave. She ordered Ali Mata to leave. Number 15, the Indiana rules on access to court records establish no basis for distinguishing between the media and the public in affording access to public records. Likewise, it has generally been held that the First Amendment does not guarantee the press a constitutional right of special access to information not available to the public generally. Hoo-hoo! More case law thrown in your face, Judge Gull. I love it. First Amendment right of access to criminal trials is a right held by the public, not the media. Get that? By the public. The public. We're supposed to be able to see this trial, not necessarily the media. It is my intention and desire to view the exhibits under the same conditions as those afforded to the media. My doing so imposes no additional burden on the court, as I would simply enter the well to view the exhibits the same as members of the media are allowed to do. This court's prior exclusion of a member of the public from the same viewing opportunity deters me from doing so out of fear that I will be banned from the courtroom and prevented from continuing to report on the events of the trial. By this motion, I am requesting to modify the court's October 16th order to permit members of the public who have obtained seats allocated to the public for the trial day to view the exhibits on the same terms and under the same conditions. So she wants the exhibits electronically, and she also wants to see them at the end of the day because it is her right as a member of the public. It is all of our rights. So she's fighting for all of us. I have reviewed the published order denying writ of mandamus and prohibition filed by the Supreme Court of Indiana on December 11th, 2023, under Supreme Court case number blah, blah, blah. That proceeding concerned the omission of court records from the chronological case summary in the present cause. While ruling that the petition was moot because subsequent to the petition's ruling, this court restored the omitted items to the chronological case summary and made them publicly accessible, the Supreme Court nevertheless reviewed the requirements to seal court records from public access, stating in conclusion, we expect all Indiana courts to comply with these rules. But that's the problem because Judge Gull was not adding things to the records and deleting things from the record, and she's not supposed to do that. In the present matter, the entire case has not been sealed pursuant to Rule 5A, and the requested materials, audio recordings, or transcriptions of the trial proceedings required under Criminal Rule 5 and the exhibits admitted at trial do not fall under any of the enumerated documents that may be sealed pursuant to Rule 5B. So she's like, you know what? All these things, audio recordings, uh, transcription of the trial, everything is allowed to the public. It does not fall under the seal rule. Consequently, the materials may only be withheld from public access after following the notice and hearing procedure required. Sorry, the dog. All right. Consequently, the materials may only be withheld from public access after following the notice and hearing procedure required by Rule 6 and based upon the findings. So there should be a hearing and this needs to be the findings. Number 1, the public interest will be substantially served by prohibiting access. Number 2, access or dissemination of the court record will create a significant risk or substantial harm to the requester, other persons, or the general public. Or 3, A substantial prejudicial effect to ongoing proceedings cannot be avoided without prohibiting public access. So she has to meet these three requirements. And so far, she says no such proceeding has occurred in the present case, and in any event, the required findings cannot be made because both the trial proceedings and the exhibits are already available to the media and the public in attendance. So she's like, you can't argue any of these because it's already available to the media and the individuals that are attending trial. They've seen them. So you can't argue any of these 3 points. They're moot now because they have been made public. They've been published to the record. I know she knows this. She is a judge. She just forgets, I guess. It's easy to forget when all the power that you have goes to your head. I respectfully submit that this request must be granted under the applicable rules cited herein at the and the Supreme Court's order. I further submit that this request is consistent with the strong societal reasons for allowing public access to court records, recognizing by the commentary to Rule 1 of the Indiana Rules on Access to Court Records and Supreme Court's order. Wherefore, based on the foregoing, the court is respectfully requested to enter an order providing as follows. Number 1, granting the motion to intervene for the limited purpose of requesting public access to court records in the present cause. 2, directing the court reporter or clerk of the court to provide a digital copy of the transcript or electronic recording of the trial proceedings each day by email, cloud-based storage medium, or a thumb drive provided for that purpose. And 3, allowing members of the public who are present in the courtroom each day to view the trial exhibits on equal footing with the access afforded to the media under the court's October 16th order, and it is signed Andrea Burkhart. I believe this was submitted on Monday or Saturday. I'm not sure. Oh, yeah, Monday. Um, at 3 a.m. She was up late. She was up late filing her court document and working out the kinks on what she wanted to say. I thought it was excellent. She drove home really great points, and with the case law that she's citing, it's really hard for Judge Gull to say no to this, but we know she probably will. So those were just the motions. Sorry, that took a while here. And now we still have to get into day 3 and the testimony. So let's get into that. Let me make these a little bigger here. All right, so like we did last time, I'm going to go through a couple different people's Twitter accounts, X accounts, who have been posting threads and things on the case while they're there. So we can learn different perspectives. I want to give you different people's perspectives. It might be repetitive, some of it, but I think it's really good to hear from multiple individuals who are there and reporting and just see different perspectives. So let's get started. This is Caitlin Kendall, and she is with WRTV. Good morning, Indiana. She says Delphi Day 3, latest on this thread, recessing until 1. She says a brutal, emotional day, 90 minutes of crime scene photos, 42 shown to the jurors. Jurors and family visibly uncomfortable. 2 witnesses took to the stand this morning. Deputy Darren Giancola, a detective for Carroll County Sheriff's Department. He was the first LEO on scene. Emotional testimony when describing seeing Libby and Abby's bodies. Giancola says, quote, one was nude, the other was clothed. Both had large lacerations to their throats. They both had a substantial amount of blood on their person and underneath. It's interesting because everybody says that Abby was like pristinely clean, like nothing was on her except maybe a little dirt on one of her feet. She goes on to say, Prosecutor McClellan asked if life-saving measures were performed on either of the girls. Giancola said no, it was apparent they were both deceased. Giancola was crossed by defense attorney Andrew Baldwin. He was asked to clarify the topography of the area at the end of the bridge and where the blood was. He testified to Abby's pants appearing wet. So that is something else that other people have reported that Abby was wearing Libby's pants, but they seem to have been wet. I believe she was wearing Libby's pants. I know she was wearing Libby's part of Libby's outfit. All right, so Paige, did I miss something? Gene Cola was crossed. He testified Abby's pants were wet. The state calls Jason Page an ISP CSI, so he's with the crime scene investigation. I could think of what it stood for a second. He does the crime scene analysis. Page was responsible for photographing the crime scene. 42 images were shown of the girls' bodies and the crime scene. Page testified to the topography of the area of the crime, of the crime scene and explained in detail all of the images he took that day. His testimony was calm, a bit mechanical, and very explanatory. Page was cross-examined by Brad Rosie. Rosie's questions were heated when asking about the integrity of the bullet at the crime scene. Rosie asked about the lack of photos of the bullet itself or any photos/videos of it being removed from the ground, because there are no videos or photographs of it being removed or being found, being collected, all of that. Page testified to suggesting the state hire a blood spatter expert after the defense became interested in a tree at the crime scene with blood they said was placed there. So this is the F tree. They named it F tree. The defense has argued before they believed the blood was a symbol of sorts. Page was questioned by Rosie and DNA about DNA and how long it takes to test a DNA in a crime scene. He testified it depends. It could take days or weeks to test, but it could be rushed. Rosie began asking questions about why the bullet wasn't photographed once out of the ground itself. Answer. Or no, question. Wouldn't it be helpful to know what the same cartridge plucked out of the ground was the same to be used in the courtroom? Page responded, yes. He also said, how a bullet affects this case is not my interest. Anything we see that could be evidence, we take picture of it in evidence. Or we take a picture of it in its place, he says. Page testified that his main responsibility was to photograph the crime scene. He was not responsible for moving bodies, deciding what or if DNA could be tested. The state calls Dwayne Datsman to testify. He was an ISP CSI at the time of the homicides. His testimony centered around photos that he took at the crime scene from an aerial view in a helicopter and from the ground. Datsman testified to finding the bullet at the crime scene between Abby and Libby's bodies. Datsman was cross-examined by defense attorney Andrew Baldwin. Poignant with his questions, Baldwin tried to emphasize the defense's interest in the bullet at the crime scene, arguing that they believe more photos should have been taken of the bullet found at the scene. He asks, would you agree with me that a bullet found at a crime scene should be photographically documented? Datsman says yes. Baldwin then asked why no videos were taken of the bullet. Datsman said photos would be better. Baldwin was working to cast doubt on the crime scene investigation techniques. Baldwin asked, if you had to do it all over again, would you have taken a photograph of the other end of that bullet? He said, if I had to do it, I imagine I would have. Indiana State Police CSIs photographed the scene, testifying to hundreds of images taken to preserve what the scene looked like. The state called Brian Olehi, I believe is how you pronounce it. That's what Bob Mata said on his stream. Olehi. So Brian Olehi is ISP crime scene investigator to the stand. Olehi was responsible for photographing the crime scene. So who was the other guy? He just did the bullet. Maybe he was. I mean, they were both part of photographing the crime scene, right? Oh, but it says this guy was responsible, so I don't know. Maybe they had two cameras. He explained how ISP took photos of the crime scene and the way it was when they found it before carefully removing items individually, packaging them, and sending them to an ISP lab to store them. All witnesses were asked if they had weapons on them the day that they were at the crime scene. Two of them stated that they were not carrying them. This is a point driven heavily by the defense, who say it could be possible the bullet at the crime scene could have come from a law enforcement officer's weapon and not Allen's. During Olehai's testimony, he shared crime scene photos of both Abby and Libby's bodies. In the photos, Olehai testified to Abby wearing Libby's jeans and they were muddy and wet. He testified to slit or dirt silt or dirt being on Abby's clothing and feet, despite her having a shoe on. Olehai also stated that they found Libby's phone and shoe under Abby's body. So the other shoe of Libby's was under Abby's body, and the other one was found with a tie-dyed shirt. All right, so that is the end of Caitlin Kendall's. Let's read a couple from Kyla Russell. She's with Wish News 8, also Indianapolis, local news. All right, update. Kyla says, updates from session 1 of day 3, so the morning session. The first witness called to the stand was Deputy Darren Giancola. He was the first deputy to arrive on scene after the girls' bodies were found. Then came at least 42 graphic photos of the crime scene. They were taken by ISP CSI John Page. Below are my observations. Libby was naked and Abby's clothes looked damp. There were at least 4 bloodstains on the ground or nearby trees. Libby had significant blood on her hands and neck. Abby also had bloodstains, but not as many as Abby. Branches were placed on the top of the girls, more so on Libby. Libby's mom and sister were visibly emotional. Richard Allen's mom and stepdad were holding hands as photos were shown. Richard Allen did not have much of a reaction to the photos, but you got to remember, he's told not to have a reaction. He's told to sit there and look stoic throughout the trial, no matter what. And he's probably seen them before, so it's not shocking to him. All right, so next, Kyla Russell says, new a CSI on scene is unaware of any DNA at the Delphi double homicide scene that ties Richard Allen to the scene. I think is what she meant to say. So at this point, investigators actually said there's no DNA that they found that ties Richard Allen to the scene. No DNA. Let that sink in. All right. Also, another update from her, also of note, the defense is focusing their cross-examination on 3 main things. Who was carrying a firearm when responding to the scene, what kind of firearm it was, and if the person's phone worked from the area. Which, because the prosecution is arguing that her phone just stopped working and then just started working again without anyone moving it or interfering with it, because they say that it was there all night. But it doesn't appear that way, because the last signals were like at 4:30 at night on her phone, and then the next ones were at 5:30 in the morning. For some reason, she was not getting any signal. Maybe it was on airplane mode or turned off or something before it was turned back on to the network. All right, so this next individual, this is Dave Bangert. I read his last time. He did a really good summary of everything, so I'm going to go through his again. Wrapping up, so he's with, what is this? The Lafayette, right? What does he write for? It doesn't say. Oh well. Whoops. I lost my spot. Here we are. This is based in Lafayette, Indiana. That's his column, I guess. The name of the column, based in Lafayette, Indiana. All right. So, the Delphi homicide trial, a brutal day 3 by all accounts, he says. Wrapping up reports from the courtroom in the trial of Richard Allen as photos of Abby Williams, Libby German at the crime scene are shown to jurors, plus defense questions use of the bridge guy audio. So he's going to tell us, he's going to tell us all about day 3. By all accounts, Monday, the third day of testimony in the trial of Richard Allen in the 2017 homicides of Delphi eighth graders Abby Williams and Libby German, was a brutal one in Carroll Circuit Court. According to Pool Media reports, the warnings given to the jury in last week's opening arguments were for the scenes displayed Monday, with dozens of detailed crime scene photos of the girls as they were found on February 14th in the woods near the Monon High Bridge Trail in Delphi. Here were a few of the key takeaways from Monday based on Pool Media reports. So this guy is getting the media reports from everybody that was there, like their pooled reports, and then he's writing them up in an article, which I think is great. Hold on one sec. My throat is getting dry. I need a sip of water. All right, so here are a few takeaways. Carroll County Sheriff's Deputy Darren Giancola was the first officer on the scene after a community search discovered the girls' bodies north of Deer Creek at the afternoon of February 14th, nearly 24 hours after they were dropped off for the hike. So it was sometime in the afternoon they found them, I think. Giancola testified he joined the search for the girls on February 13th, an off day from his job. He testified that he'd been near the cemetery along County Road 300 North the next day when others searching for the girls pointed him to where they were. So, hold on one second. I'm going to bring up the map. All right, sorry. So here you can see the map of like an aerial view of Delphi. So downtown Delphi would be to your left of the screen, like it's off the screen. So we're just looking at the overview of this Deer Creek area. So Freedom Bridge is right above where it says downtown Delphi, and you can see my mouse moving on the screen. That's Freedom Bridge. Hoosier Heartland Highway is running up and down this way. Here's the creek, which you can see running it's twisty turny. And then you got the Hoosier Harvest Store, which has the video cameras that are facing County Road 300, which is right here. So anyone that went past would have been recorded. Here's the cemetery where this deputy was, or nearby. He was near there before he came to where Abby and Libby's bodies were found in this area over here. And then here's the Monon High Bridge, which it's been confirmed by multiple content creators that you can see the fish from the high bridge. And here's the trail. So if you look where my mouse is in the middle here after the Hoosier Harvest Store, there's an entrance to the Monon High Bridge. So there's not really much area to park or anything like that, but that's probably why whoever it was parked near the stores in that area, or the old building that was in there. So this is where you would enter, or this is where they entered in this Mears entrance right there. And at some point in time, they got to Monon High Bridge, but at some point they were told go down the hill, and we don't know what happened from there. It's a mystery. So there you have it. I always like to give you guys a visual when I can. A lot of you, me, myself, and I, also are visual learners, so it helps to get visuals whenever possible. He said one of the girls was naked and the other one was clothed. Both of their necks were cut. It was apparent they were deceased, according to him. Next up, Sergeant Jason Page, an Indiana State Police crime scene investigator, detailed how the crime scene was secured. Through crime scene photos of the girls, Page described how Abby was wearing a dark blue sweatshirt lying on her back, right knee bent, and right foot under her left leg. Hold on, let me show you that too. And a back. All right, so I had to find this. So here, these were two different depictions that I found. One on your left is from another YouTube channel called True Crime Design. And they illustrated that. And then the other one is from, you might even recognize, Court TV, their graphics. So these are images of what the girls' bodies looked like. So trigger warning, apologies. I should have given you a trigger warning before I flash it on the screen. Um, and I heard from some experts, some panelists on, I can't remember if it was Core TV or what, but they said that not just the sticks, don't pay it, like pay attention to the positioning of the sticks, but also their body could be part of the rune too, or could be the way that their body is positioned could be a rune, and then they could be doubling it with another rune. They said doubling runes together or combining runes together for certain things can make your spells more powerful. We went over that. I can't remember when. It's been so long ago, but yeah. So, anyways, as you can see, Libby here with the very large branch that goes across her arm, and the way that these sticks are shaped, you can see it's like a V. It almost comes into like a V here, and then you've got this crossbar, and who knows if that's another part or what, if those mean something. And then here you can see Abby's got what appears to be some kind of like an antler, and obviously she's got sticks across that are different too, so they go in different directions. And her arms, I believe it described her arm. She's in, I believe this is the sweatshirt that Kelsey lent to Abby. Or to Libby. I'm sorry. Kelsey lent it to Libby that day, and this is the sweatshirt, the Delphi swimming sweatshirt that she said was brand new, which she kept repeating that. I don't know, something about that. And there was hair in Abby's hand. That's not Libby's, and not Richard Allen's, because he wore his hair short and it's a longer hair, so it could be a female's. So that's interesting. Maybe it's Kelsey's hair in her hand. I don't know. They didn't DNA test it that we know of yet, or they're still waiting on results. So that gives you a better idea, hopefully, of what the crime scene looked like. And I'm sorry, again, apologies, but it's a graphic topic, but we learn from this. And I think it's important to show these things to learn. And this specifically because there might be some ties to Odinism or some kind of Norse god religion thing that uses runes, which I'm going to get into. This is just, again, what the positioning of Libby's sticks looks like, and then again, what Abby's sticks look like. Down here, this is the F tree. Let me zoom out a little bit. So this is what appeared on the tree, this pattern here. And as you can see, they kind of overlaid it with an F. So it does kind of look like it could be an F or something along this F rune, which means, I'm not even going to try to pronounce that, cattle, um, meaning is wealth. Cattle, livestock, wealth. That was from two different sources where I got that F rune, which could be if they are doing some kind of ritualistic sacrifice of these two poor innocent girls, and putting that on a tree is their ultimate desire to gain wealth and power, because that's what this F rune does. So that's what I'm thinking. Cattle means wealth, wealth means power, all those things. So they're trying to become more powerful and wealthy in whatever way that means to them. So, yeah, that's my take on that. And that's what I would venture to say. So these, I don't know if you guys are even familiar with runes. I remember when I was a kid, I've always been into like spiritualistic things. I've always been into spirituality, talking to ghosts, reading runes, tarot cards, things like that. I actually do read oracle cards. And when I was younger, my sister Jenny had these. She had a bag of runes. They were in like this little velvet bag, and they looked just like those, the white ones. There, she had almost like that. And each rune has a different meaning, different, different kinds of things, different combinations of runes mean different things. So it was always kind of fun as a kid going through the runes, asking questions, and then like reading what all the meanings were. And I always enjoyed that. Well, that's what runes are. They're kind of like a fortune telling oracle type thing, but they can be used in this Norse religion, this Odinist or whatever you want to call it, religion that they're in, to maybe be used in more of a satanic way or an evil, nefarious way. Everything that's good can also be used bad. Everything that we have, we can use in excess or we can ruin it by turning things evil. So these kinds of runes they're not inherently good or bad. It is the person who is using them. So these people who are using them obviously are not they don't have the greater good in mind. And that's what when you are using them for uh runes, oracle cards, whatever, you have to have like positive intentions, I would say. Anyways, in Odin we trust, and this other patch, which is half of a flag, and then these three triangles all hooked up together. These are common Odinist symbols. These are the patches. These are representations of what the patches looked like from the Odin guards. Just an FYI. This was a presentation I did long back with the Frank's memo. But I wanted to go back over it. You probably, if you haven't done it or gone through my Frank's memo, I do the whole Frank's memo in multiple parts because it's a long document. But this was a presentation that I put together to help explain the positioning, the runes, all of that. This is the Hangman tarot card, which is a very common card in tarot. And as you can see, the legs are split like that, which is almost like how Abby's legs are, how they were positioned underneath her. One leg is under the other. And interestingly, I listened to the Defense Diaries summary on day days 3 and 4 and or 3. We're on 3. And they did say that because they actually saw the photos, they saw the actual photos that were displayed on the screen. They displayed it for the whole gallery to watch as they went through all 40 something photos. And it Bob Mata said it looked like, because Libby's throat was slashed in multiple spots apparently, but it looked like the way and the direction in which the blood may have drained would have been up her face, meaning she might have been hanging upside down, which is another thing that is eerie about this, which I have wondered myself if they hung Libby upside down. That's just speculation. I don't know, but I wonder if they did either one of them. It might have been either one, or it could be either one of them. But this hangman symbol is very important to the Norse Odinist religions because um, Odin himself did this position. This is Odin. This is, yeah, he's like went and hung on a tree for a while. I don't even know the whole story, but it has something to do with how Odinism began or originated or something along those lines. So Yeah, these are just different versions that I found for you guys. And then those are sketches. As you can see, we've gone through that. And then here are a bunch of pictures of the girls, which I put together, which I thought was nice of looking. All right, let's get back to what we were talking about. So we were we were on this article and then we got way off track with this, but I thought it's always good to show visuals. So let's get back to Sergeant Jason Page. He says he detailed how the crime scene was secured. Through crime scene photos of the girls, Page described how Abby was wearing a dark blue sweatshirt. So, all the way back up here. Sorry, I gotta do that. All right, so a dark blue sweatshirt, apparently, the Delphi swimming one. Lying on her back, right knee bent and right foot under her left leg, like I pointed out. He testified that Abby's clothing seemed damp. So that's the second person now who has said that. Page testified that the scene was saturated with blood on the ground. Trees near the bodies also had blood on them, he testified. Page also testified about an unspent bullet found at the scene and was a pivotal piece of evidence in the prosecutor's probable cause affidavit when Allen was arrested in October 2022. Page testified that the investigators used a blue light to locate the bullet after the bodies were moved. So they used this blue light and it shimmered or glittered, as they called it in court, and it that's how they were able to find it. They didn't see it with their own naked eyes. They had to use this blue light to find it, and it wasn't buried, but it was like hidden, if that makes sense, by like leaves and brush and things. All right, so Dwayne Datsman, a former Indiana State Police crime scene investigator, our next witness, was challenged by Andrew Baldwin, one of Allen's attorneys, about why police hadn't taken photos of the unspent bullet where it was when they found it. And a juror asked a question via Judge Gull whether there would be any reason on the bullet presented as evidence would whether there would be any reason on the bullet presented as evidence was a different bullet. That doesn't make sense to me. Yatsman said there wasn't any reason that the bullet presented as evidence was a different bullet. Is that okay? So maybe that's what they were saying. I don't know. Maybe that there's an error in that sentence somewhere. Um, Dats said that there wasn't, so meaning that it was evidence from the scene, apparently. So Datsman also testified about finding sticks and limbs on and around Abby and Libby's bodies and how they were removed. Whether sticks found on the girls' bodies were evidence of an old Norse religious ceremony and eventual ritualistic taking of their lives by a group not connected with Allen has been a key theory for the defense. We know that through the Franks memo. One, the judge ruled wasn't allowed. So she did not allow the talk of Odinism, Norse religions, blah blah, all that. So I'm hoping they can somehow get it in some other way, but we'll see. Baldwin also pressed Statsman about why investigators didn't take the sticks as evidence, leaving them in the site until March 3rd. The sticks, the runes, the sticks that I just showed you. All those sticks. There were also piles of blood with sticks, by the way. Someone had drawn like a little diagram where there were piles of blood, and in one pile, like near or under Abby, there was a pile, and then it had sticks, like some other kind of rune. So everything, it seems like everything on the set or on the scene had some kind of symbolism to somebody. Who and what it meant, I don't know, but somebody understood it. Testimony Tuesday is, and oh, by the way, I didn't drive home that point. Lastly, is that those sticks, they were not collected as evidence until later. And at that point, they're contaminated because you didn't take them at the time of the crime, and um, you didn't think they were somehow important. They said something about he said something on the stand, I think, about the fact that he thought that they didn't have any evidentiary value. So I don't know what that means. I mean, I know what that means, but I think that's not. I don't think that applies because they were covering the girls and piles of their blood. So I don't know how that's not evidence. But I'm not a cop. Don't ask me. Okay, moving on. Testimony Tuesday is expected to pick up with Brian Olehai, who was another ISP crime scene investigator. On the stand Monday, Olehai gave details about the scene, the clothing that was found there, and the pools of blood near the girls' bodies. For more details from reporters in the courtroom, there's a bunch of different links that he gives in his article. This was, again, Dave Bangert with based in Lafayette, Indiana. All right. So lastly, oh, I can close that. Lastly, I want to get to Angela Ganote is how I'm going to pronounce it because I think that sounds fun. She's with Fox 59 Morning News, and she's been also tweeting, reporting on this. So I'm going to give her her shout out here on X. She has, so this is day 3, morning trial notes. My colleague, Fox 59's Russ McQuaid, was in the court this morning. These are his observations. Testimony started with the first deputy on the scene and an ISP crime scene investigator. So we knew that. 42 crime scene photos were entered into evidence and shown to the court and to the jurors. The photos included everything from the general area to close ups of Libby and Abby. Abby was dressed, Libby was naked. The clothes Abby was in appeared damp. There was blood stains on both girls, on the ground and on the surrounding trees. So, was that the only rune that was painted on a tree? Were there multiple trees that had blood painted on them? I would love to know because we know they didn't take pictures of the bullet. So why do we think that they took pictures of everything on the scene? Why are we supposed to believe that there weren't trees that had other runes on them, painted on them, and they didn't take pictures? I don't trust this investigation one bit. So there were tree branches set up that appear to be a pattern on top of the girls. Some were in V's or crosses, some with large branches. The suspect, Richard Allen, looked at the pictures as they were shown, but Russ said he had no significant reaction to them in his opinion. Still in direct examination, court starts back at 1, then she goes to her afternoon notes for day 3, per Max Lewis, another colleague of hers. So testimony continued from State Police CSI just after 1 p.m. The bullet found after moving the bodies of Abby and Libby was not easy to see. Remember, they used the blue light. It was found using a blue light that showed a sparkle. Investigators did not take any pictures or video of the bullet in the ground or of it being removed. That's very significant. The bullet was put down and depressed into the ground. So, or point down and depressed into the ground. It wasn't buried, but it had been almost like somebody maybe walked on it and it like sunk into the dirt, but it was still above ground, if that makes sense. So investigators did not collect branches that were on the bodies for any testing. They said they've never gotten DNA off branches. They've never gotten DNA off branches. Well, maybe you should try one day, like today. They found no noticeable shoe impressions in the area. The investigator was not aware of an R kit being done on either of the victims. So, how do we know that there was no assaying happening? Added, they never measured the depth of the nearby creek to determine how easy it would have been to cross. Max described it as a contentious cross examination. That's interesting. That would have been fun to see. I would like to see. People are describing Andrew Baldwin as kind of like just like a ho hum, nice guy, nice older gentleman, and like easily weaves you in and sets you into a trap for a question that he's gonna pull out later at some point. Like he's like setting them all up and putting them in his pocket for later, if that makes sense. All right, so Angela continues on saying, just an emphasis here. So this was after the trial, ap- after the afternoon notes. She says, just an emphasis here. What is typed here is from LE investigator, law enforcement investigator, who said he personally did not know if an R kit was done. If he was not in the room, he can't say, yes, there was one done. We are taking you through what is happening witness by witness. Also, since we can't have camera or audio detailing everything, this is coming to our team through multiple humans writing and listening and then sharing their notes. So they're doing a really good job, I think, of keeping us on top of it since there is no audio and video. But hopefully we get a transcript from Andrea. That would be awesome, Andrea Burkhart. All right. So her final notes for trial day 3, CSI investigator Olehai on the stand discusses where Abby and Libby's shoes, clothing, and cell phone were found. Libby's shoe was found in the river. So one of her shoes was found in the river. The second shoe was found underneath Abby. Libby's phone was under Abby's shoe. So the shoe was covering the phone, and then Abby was on top of the shoe. That makes sense. Libby's shirt was on Abby. Libby's other clothes were inside out and in the creek. Abby's hands were inside the shirt, clutched on her chest. So, like, she had her arms up like this, and she had her hands, like, inside the sweatshirt, clutched on her chest, feet pointed north. The investigator, Olehai, said the branches from the crime scene discussed earlier had blood on them and were recovered and taken into evidence, but 2 days later. I thought it was way later. But anyways, yeah. So later. Russ and Max said it was clear that the sticks were also arranged in a specific way on Abby and Libby. So somebody did it intentionally, purposefully. There was purpose there. There was a reason behind why those branches were in the shapes that they were. It wasn't just to try to cover up the bodies because they weren't covered. As you can see, you would easily be able to see them. It wasn't like they were trying to hide the bodies. It was a symbol, something. What? I don't know. Russ and Max said they were specifically arranged. They also clarified there was a photo of the bullet on the ground, but that was the only photo. No photos of it coming out of the ground. You can't see the end of it. Defense hit hard on chain of custody from in the ground to evidence. So there was a lot of chain of custody broken there. Tomorrow morning, Olehai is back on the stand to continue. So that is where I'm going to leave you for um, uh, for today, and then we will pick up with part or day 4, and we'll go over that in the next one. So make sure you are subscribed. I hope you guys like these recaps. I'm trying my best to get you guys what I can out to you so that we all feel like we have some kind of idea of what's going on because we need to shine light on this case. So thank you guys for being here. Let me know what you think of badass Andrea Burkhart's motion. I thought it was great. She's pretty badass. That was pretty much telling Gull to stuff it. when it comes to her media BS that she's pulling right now because it is obviously some BS. All right, well, I will leave you guys at that and I will see you in the next one. Take care. Thank you so much for being here. Please hit the like button on the way out and I'll see you guys. Bye.